We are all set to start. Well, very recently we had our former governor of RBI, Shri Urjit Patel, opine that the current banking challenge is almost intractable one even before COVID. While we also had the Reserve Bank of India in itself predicting that in July this year that bad loans could be as high as 12.5% by March next year. It is in this backdrop that we have had our very prolific speaker for today, Advocate Amrita Kharkar, who very kindly obliged to set aside her valuable time to throw insights on a very pertinent topic, that is overview of the Insolvency and Bankruptcy Code, SWOT analysis of the new amendments. I welcome all of the participants to this intellectual discourse. I request all the participants to reserve all your queries to the chat box, and a separate link with regards sharing the feedback about the speaker would be sent later on. I now take great privilege as well as pleasure to introduce our speaker for today, Advocate Amrita Kharkar. Advocate Amrita Kharkar is the co-founder partner of the law firm KV Legal. She is a practicing solicitor in the field of real estate and insolvency laws. She graduated in law from the Pune University, and thereafter she qualified as a solicitor and became a member of the Bombay Incorporated Law Society. Her determination, past experience in the field of law, and her passion to work in the legal field has resulted in establishing her own law firm. Her expertise in drafting and vetting of agreements and success in several matters before various courts is being rewarded by way of satisfied clientele. With this brief introduction, Madam, the platform is all yours now.
Thank you so much for the brief introduction. It's my pleasure to be invited here for this session. I would definitely like to enlighten everybody as far as the current scenario as the banking sector is concerned, or the current NPA status and the light of the COVID scenario that is going on. So I would directly start with my presentation, which will help us to understand the entire situation. Let me just start with the screen share here. Yeah, so I hope everybody can see the screen share. Will that?
Yes, ma'am, we can.
Okay, so I'll begin now. So my today's discussion is primarily revolving around the Insolvency and Bankruptcy Code. I shall be giving you an overview of the entire code and also explaining to you all the current amendments which have come in light of this COVID-19. But these amendments are very important to be understood from the perspective that they're going to bring a whole lot of change to our current economic system. So let us start with the very understanding of the code, the entire overview of the code. Now, before we proceed with what this code is all about, I would like to explain just in short what those terms are: the insolvency, bankruptcy, liquidation. Because it's very important that before understanding a particular code, these terminologies play a very vital role. So our first primary term is insolvency. Now, what does insolvency actually stand for? It is an inability to pay the debts. It is a time when the liabilities exceed the assets. So it is very important to know that insolvency comes in or triggers in when there is an inability of a corporate entity or an individual to pay their debts. Then comes the bankruptcy. Now, what is bankruptcy? Bankruptcy is when a person is declared incapable of paying their dues by a competent authority. So it is a competent authority or an adjudicating authority which decides that this particular entity or this particular individual needs to be declared bankrupt because they are unable to pay their dues. Then comes the process of liquidation. Now, what is liquidation? Liquidation is a process of the winding up of the company on being declared bankrupt by a competent authority or an adjudicating authority. Now, what was the
Trump
need
was to
for this code?
propose,
There would definitely be some
Trump
need for
was to
this code which needs
propose,
to come in. Is there
Trump was to
somebody's
propose,
uh, video
Trump was
mic on? Because I feel that there is
to
somebody
propose.
talking behind. Xenia, if you could just come in for a minute.
Yes, ma'am, we are looking into it.
Yeah.
Ma'am, you can please continue.
Yeah, okay, fine. Thank you. So, what is the need for the code? Now, prior to the enactment of this insolvency and bankruptcy code, there were multiple laws which were in place and which still continue to be in place. And there were multiple forums which were there in place. So, therefore, a need was felt that, we have one consolidated forum which will help us to come out of these insolvency and bankruptcy issues. So, what were the different types of laws which prevailed prior to the insolvency and bankruptcy code coming into place? Was the Companies Act, which had the voluntary winding up. We had the MSMED Act. We had the Surface Act. We have the SICA Act. We have the RDBFI Act. So, all these acts came into being and they were helping
Learning
in
the art
some
of
way or the
learning the
other
art of
to come forward and help in
learning the art of
getting
how to play out
insolvency
success. Learning the
resolved or
art of how to
bankruptcy resolved. But somewhere it was felt that they were not efficient enough, or that these insolvent companies who could have been revived were not being properly revived. So we even had different kinds of forums. We had the BFR, we had the DRT, that is Debt Recovery
Error,
Tribunal, we had the
error,
High Courts, we had the appellate tribunals, we had the CLB, there is a company law board then. So it was all these forums which were in place. Thereafter, there were a lot of NPAs which were happening every now and then. So the government had the thought of putting a stop to these NPAs by coming up with some restructuring programs. So they did come up with RBI policies of restructuring, but then somewhere they felt that they were not efficient enough for the restructuring of these companies, and therefore the need for the code was felt, and finally the code was enacted. Now, what is the object of this code? Now, this is very vital for us to understand, because insolvency and bankruptcy code is to be understood as the revival of a company or an individual. It cannot be construed as something that is a recovery tool. Mm, This has to be understood because it is by no stretch of imagination a recovery of monies due from any person or a corporate entity. Now, what is the object of the code? That this entire insolvency process has to be completed within a fixed time frame. The priorities of payments which have to be done under the code are very categorically listed out. It is a maximization of the assets of the corporate debtor. You cannot sell the corporate debtor. You have to continue the business of the corporate debtor. It minimizes the role of the adjudicating authority. Now, what is it that it minimizes the role? That means it actually reduces the burden on the courts. Now, how it reduces, I shall explain you down the line, but these are certain objects of the code which are very important. Recovery cannot be a tool. So, suppose, for example, that there is a debt which is due, and just because that person is not paying me my debt, I will take him to the NCLT, or that is the insolvency code. No, this is not recovery. The Supreme Court has also made it very clear in its judgment, which is of the Mobilox Innovations Private Limited versus Kirusa Software Private Limited, that this is not a recovery tool. This is a provision only where companies require to be revived, and insolvency has to be considered in light of the revival of the company. Then it also balances various stakeholders. It also promotes entrepreneurship. That is, new people can come in and take over the businesses of the company if the previous promoters or the directors of the company are unable to conduct the business. So many times the business might be viable, but the management may not be able to lead the company, and hence the company may not be doing good. As a result of which, this code helps new directors or promoters to come in to take over the company. So all these are the objects. For if you want to read more on the object of the code, you all can refer to the case of Binani Industries versus the Bank of Baroda, which will clearly lay down the object of the code, and it will help you to understand the code much in detail. Next, I move on to the applicability of the code. Now, when this code it was enacted in different parts, but it was notified also in various segments. Now, when I say that it is applicable to certain entities, which are those entities? It is applicable to the Companies Act, it is applicable to the limited liability partnerships, it is applicable to partnerships and proprietor firms, individuals, and also to personal guarantors of corporate debtors. But this all these segments are not yet notified by the government. What has currently been notified is the companies and the limited liability partnerships. And recently, in December 2019, the personal guarantors provisions have also been notified. That law is still untested, but yes, it has been currently notified. So, as far as partnerships are concerned or proprietorship firms are concerned, they are yet to be notified. Individuals are yet to be notified under the code. So this is about the applicability of the code. Now, in this current lecture today, what I will be actually discussing about is the notified portions of the code. Now, the primarily notified portions of the code are the companies and the limited liability partnerships. So, the entire insolvency process for companies or the limited liability partnerships is called by the name of Corporate Insolvency Resolution Process, that is the CIRP in short. Now, how does this entire process begin? When does it start? What is the need for this process? So let's, before getting into this entire understanding, understand what do we mean by the word debt. Now, debt has been defined under the code into two various parts. One is the financial debt, and the other one is the operational debt. Now, what is a financial debt? A financial debt is basically a debt where someone has lent monies with interest against the consideration for the time value of the money. So, a financial debt would mean that a bank has given loan, or some financial institutions or the NBFCs have given loans to the corporate debtor, as well as a operational debt. Now, what is an operational debt? An operational debt is somewhere where goods or services, a claim which arises from the goods or services. So, for example, someone has provided service to a company and the company is unable to pay the amount for the services or the goods delivered, is when the debt will arise. So when there is a financial debt or when there is an operational debt, there comes a financial creditor or likewise an operational creditor. So an insolvency can be triggered either by a financial creditor or by an operational creditor. Now, when I say financial creditor, it means that the financial creditor would have raised a claim or a demand for the amount which was lent by the financial creditor, and likewise goes for the operational creditor. But what is important and pertinent to note here is that the code makes it very mandatory for a operational creditor to issue a demand notice, whereas that mandatory criteria is not there for the financial creditor. A financial creditor can raise a demand notice or may not raise a demand notice, but an operational creditor has to raise a demand notice before the operational creditor goes to the court. And then the third person who can initiate the CIRP process is the corporate debtor himself. That in the event the corporate debtor feels that yes, the business is not viable and that his current liabilities will help him to settle all the outstandings and all the liabilities, can definitely go for the insolvency process. So there are three types of people who can initiate the insolvency process. One is the financial creditor, second is the operational creditor, and third is the corporate debtor himself. Now, proceeding next. Now, what happens further? Now, we know that there exists a debt, which debt is due and payable. So, how do I now take this particular debt and go to the court? Now, which is the forum for this? It is the National Company Law Tribunal, where an application has to be made, a company petition has to be filed. So, what happens on filing? A company petition is filed in NCLT and then it has to be admitted. So if the company petition is not yet admitted and the other party comes forward and settles off the payment of dues, fair enough, the case does not proceed further. But what happens on admission of the petition? Now, this is where your insolvency and bankruptcy code actually triggers in. This admission of petition by the NCLT plays a very important role because four primary things happen. One, there is a period called as a moratorium period which gets declared from the date of the admission of the petition. Then there is an appointment of a person called as the IRP. The insolvency commencement date is the date on which the petition gets admitted, and the promoters and the directors of the company stand suspended. Now, in order to understand all these four factors, I'm going to deal with each four factor in detail as we proceed further. Now, moratorium. Now, what happens is that when this particular petition gets admitted, there is a period called as a moratorium period which gets declared. Now, this is a very important period and which we all should understand that this gives a breather to the corporate debtor. This does not mean that the corporate debtor can sit at rest and enjoy the period, but this is the period when the entire CIRP procedure laid out under the code is actually carried out, but no recovery agency or no debtor, no creditor can pursue any action against the corporate debtor during this period because this moratorium period is actually used to see if this particular company can be revived by bringing in another promoter or a director for the company or a entrepreneur who will take forward the company. And if the corporate debtor himself satisfies certain criteria for qualification of continuing the business, then he too can raise a plan before the IRP who is appointed and continue with the business. But however, a set of procedure has to be followed. So this moratorium period is a period which stays all the proceedings against the corporate debtor. But bear in mind that it will only stay the civil proceedings. Suppose there are any criminal proceedings, that is Section 138 proceedings, or any other criminal proceedings which are against the directors of the company, they shall not be stayed, and this benefit of moratorium will not be awarded uh, to those particular directors of the company. So moratorium period shall continue. There will be no surfacey that will come into place. That is, the debt recovery tribunal cannot proceed against the corporate debtor. Then you have any kind of a recovery of the property. So suppose if the corporate debtor is a lessee in a particular premises and the lessor wants to recover the property, the lessor cannot recover the property during this particular period of moratorium. He has to wait for the entire CIRP process to get over, which period lasts for 330 days in total. Now, then comes the moratorium period, and this moratorium period, when does it stop? It will stop on the completion of the CIRP, or it will stop when the liquidation order is passed by the NCLT. Understanding this moratorium period, we shall now proceed to the next slide, and where I've earlier mentioned about the person called as the IRP. Now, this particular person plays a very vital and an important role in this entire CIRP process. Like I had mentioned earlier, the object of the code, it reduces the burden on the adjudicating authorities. This is where that particular object is very important because the adjudicating authority after admission of the petition does not come into picture. It is only the IRP, that is the interim resolution professional, who is appointed comes into picture. Now, what does this person do? This person actually takes over the management of the affairs of the corporate debtor. He sits in place and position of the corporate debtor. The powers of the board of directors and the partners of the limited liability partnership will fall in the hands of the corporate debtor. The officers, the accountants, the managers, all are required to report to this IRP. He has to protect and preserve the value of the property of the corporate debtor and manage the operations of the corporate debtor as a going concern. He cannot just stop the business. He has to come to the office regularly, see that the company continues to do the business unless there are any kind of losses which the company would incur. Then we have another person called as a resolution professional. Now, when I said the IRP, that is the interim resolution professional. It is either this interim resolution professional who continues further and becomes the resolution professional, or a new resolution professional gets appointed. Now, who appoints this resolution professional? Now, firstly, this IRP, that is the interim resolution professional, is appointed at the time of the admission of the petition. He is either suggested by the creditor. If not by the creditor, then by the National Company Law Tribunal himself suggests the name of an IRP. This IRP is then required to formulate a committee of financial creditors only. This committee is very important. It actually steers entire company, how the company will proceed forward. So these financial creditors in its first meeting will appoint the resolution professional. So this resolution professional will either be the IRP himself, or there will be a new RP which will be appointed by the committee of creditors. So once the new RP is appointed, the RP will continue the role of the IRP, that is manage the affairs of the company, communicate with the COC, that is the committee of creditors, about how the company is progressing, who are the creditors of the company, how is the business of the company currently doing. The RP is also required to then start with the process of the inviting of plans for the revival of the company. So there is again an entire process under the code which has been laid down as to how this company can be revived, as to how this company information can be provided to the public, so that if anybody is interested, can make an application to the RP that yes, that this is a viable business and that we like to go forward and continue the business as a going concern. Then here in my next slide, I have laid down in rough, which is more theoretical, as to how the steps are followed by the IRP and the RP. So the RP and the IRP are then to they have to value the company, that is understand the asset, that is the liquidation value of the company. This is very important, that this particular liquidation value of the company has to remain confidential. It cannot be leaked, because the resolution plans which will come forward for the revival of the company have to be more than this liquidation value. Because otherwise, if at the same time, if this liquidation is value leaked out to the public, then definitely there would be no maximization of the assets of the company. Therefore, the RP or the IRP have to be very sure that the liquidation value of the corporate debtor has to be kept highly confidential. And then this particular flowchart which I've shown here actually lays down the various processes by which the CIRP is conducted. You have the committee of creditors which is formulated. You have the IRP filing all the reports to the NCLT also. You have the liquidation value coming in place, and then you have the RP inviting claims from the public for the continuation of the company as a going concern. Then coming to my next slide, it deals with the concepts. Now, committee of, I have already mentioned a lot of terms like committee of creditors, resolution applicant, resolution plan. Now, what are these concepts under the code? So it's very important for us to understand these concepts, because if we don't understand them, then it becomes difficult for us to even understand the procedure which I have earlier explained to you as to how it follows. The first and primary is the committee of creditors. Now, this committee of creditors is formulated by the IRP. Now, IRP is required to take into consideration all the creditors, but shall bifurcate between the creditors as financial creditors or operational creditors. Once he has bifurcated them into operational and financial creditors, he forms this committee which will only consist of the financial creditors. So, under the insolvency code, the financial creditors have been placed on an upper pedestal because they play a very vital role. Though there have been judgments in the recent times that, operational creditors and financial creditors should be treated at par, and that only the committee of creditors should not be considered of the financial creditors. However, what the law currently exists is that the committee of creditors will consist of only the financial creditors. In the event the company does not have any financial creditors, then it will go down to the operational creditors. But primarily, if there is even one financial creditor, the committee of creditors will be only the financial creditors. Now, these financial creditors have to vote during the committee of creditors on various topics which are placed before them by the RP. Now, what is the percentage required for voting of any resolution to pass? That is 66% of the strength of the committee of creditors. And therefore, it is very important that these committee of creditors give votes which are beneficial for the going concern of the company. Now, many times, if we see that if the financial creditor sees that their claims are going to be accepted, and the operational creditors are not going to be concerned, many times the committee of creditors may pass a view saying that yes, let the company go for liquidation as long as we are getting our values from the assets of the company. But the committee of creditors cannot give that a thought. They definitely have to consider the fact that this company needs a second chance. There is a chance of revival of the company, and therefore we must consider the various applications that come before us in the light of the fact that not only their debts are due, but then there are other operational creditors, there are other creditors whose money should also be considered at the time of making any decision. Then comes the resolution applicant. Now, who is this resolution applicant? This particular resolution applicant is a person who gives an application to the RP saying that we would be interested in the company and to take over the company with the intent that we'll continue the business of the company, we will maximize the assets of the company, and that the company need not go into an insolvency or bankruptcy proceedings. And therefore, this resolution applicant has to table its plan as to how it will continue the business of the company, and it has to table its plan as to how it will continue the assets of the company. Now, this resolution applicant has to table its plan as to how it will continue the business of the company, and it has to table its plan as to how it will continue the assets of the company. Now, this resolution applicant has to also I guess I lost my connection. Am I back?
Yes, ma'am, we can hear you.
Yeah. Okay. Sorry for the connection. I'll continue again. So I was at the resolution applicant, and this particular resolution applicant is required to give its plan, and based on this particular resolution applicant's plan, we are required to consider the plan. Now, committee of creditors are required to consider this particular plan in light of the factors which have been laid down under the code. The RP also, before tabling it before the committee of creditors, have to consider this entire plan, has to take into consideration that it satisfies the very object of the code. And what is the object of the code? That is the revival of the company. Am I still audible to all?
Ma'am, you're audible, but we can't see your slide right now.
Just give me a
Kindly
minute.
share your screen.
Can you now see it? The slides. Can you now see the slides?
Yes, ma'am. Yes, we can.
Okay. Okay. So now coming to the third concept is the resolution plan. As far as the resolution plan is considered, like I've mentioned, this plan has to be for the revival of the company. The committee of creditors have to consider this plan in light of the code. Now, understanding these three basic concepts of the insolvency code, which are very vital, that is the committee of creditors, the resolution applicant, and the resolution plan, we shall now proceed to what happens when actually a resolution plan is forwarded. A resolution plan, once forwarded to the COC, that is the committee of the creditors, either approves the plan or it does not approve the plan. So in the event it does not approve the plan, the COC says that yes, the plan is not viable and therefore the company needs to proceed for liquidation, and they pass a resolution to that effect. In the event the plan gets accepted, the COC will then ask the RP to seek the approval of the plan from the NCLT. Then the RP shall make an application to the National Company Law Tribunal saying that this is the plan which has been considered by the COC, which is for the revival of the company. Now, this NCLT does not have much role to play with regards to whether the plan has to be approved or rejected. Primarily, it has to approve the plan because we have a very important judgment laid down by the Supreme Court, which is of the K. Shashidhar judgment, which clearly states that the commercial wisdom of the COC, that is the Committee of Creditors, cannot be challenged. So, if the Committee of Creditors have decided that yes, this plan will go forward, this is for the viability or the business to continue as a going concern, NCLT will approve the plan. Now, here I've also stated in this slide that the NCLT can reject the plan. Now, on what grounds can the NCLT reject the plan? That it is shown to the NCLT that this particular plan favors a particular class of the creditors, or that it is not in accordance with the code, or that the CIRP process has been violated, or the law has been violated in general. It is only on such parameters or only on such grounds that the NCLT may reject the plan and direct the COC to either reconsider the entire plan. And hence, it will be only if then that the NCLT is sure that no, that this plan cannot go through, can order for liquidation. But like I mentioned, the commercial wisdom plays a very important role, and NCLT will have to accept the commercial wisdom of the COC and pass the plan. Once the plan is passed, the company has to be revived. So the moratorium period also comes to an end, and the entire process of revival of the company starts. That is the process which has been now laid down in the plan as to how the monies will be infused by the new person that is going to come into picture, because the suspended promoters and the suspended directors will no longer manage the company, and it will be the new directors who will manage and take over the business of the company. So this is what actually happens at the end of the CIRP, that is either the resolution plan is accepted or it is rejected and the company goes down to liquidation. Now, what is this entire process timeline? That is the entire CIRP process timeline. It is first is 180 days timeline has been given. Then you can seek a 90-day extension by making an application to the NCLT, thus totaling it to 270 days. But out and out, the entire process has to be completed within 330 days, which 330 days shall also include the time taken for the legal proceedings, because many times when a matter is before NCLT, it so happens that it may not come up before the court so quickly, as we have many cases which are pending before the courts, as a result of which the entire process gets delayed, and then it becomes very difficult for the timeline to be followed. But the code is very clear that timelines have to be strictly adhered to, but then at certain times the legal proceedings do take time, and therefore 330 days has been considered as the actual timeline for the entire period or the entire CIRP process to come to an end. So this is all about how the entire insolvency process actually comes into being. Now, how is the forum, or how does the forum proceed ahead? First, we make an application to the National Company Law Tribunal. Then we have an appellate jurisdiction, that is the National Company Law Appellate Tribunal, which is in Delhi. And then we have the Supreme Court, which is the final verdict. So this is how the applications or the petitions will flow. One, National Company Law Tribunal, then we have the NCLAT, that is the National Company Law Appellate Tribunal, and lastly we have the Supreme Court. Now, my entire current talk is all about the insolvency process. I'm just quickly going to take you down through the liquidation process, which is kind of similar to insolvency, but when does the liquidation process actually kick in? It is only when the entire resolution process is over, that is the entire CIRP is over and the liquidation order is passed. Now what happens? Here I've given a very brief chart as to how the process takes place. First, you have the appointment of a liquidator by the order of the NCLT. Like we mentioned, that the plan has been now rejected and hence we have the liquidation. And for liquidation, now we need a liquidator, because under insolvency, we had the interim resolution professional or the resolution professional. Under liquidation, we'll have the liquidator. The liquidator will then make again a period to be declared called as the moratorium period, where again there would be no initiation of suits, no suits can be filed, or no suits, pending suits can continue. In this manner, the officers, the employees, and the workmen shall be discharged, except when the business of the corporate debtor is continued. You will have an issuance of public announcement, formation of liquidation assets. That is, the entire estate of the corporate debtor is then taken into consideration. It will be consolidated into one file where the entire assets have been listed out. Then claims will be invited, and then you will have the monetization of the assets and distribution of the proceeds. Dissolution of the, and finally, at the last stage, you will have the dissolution of the corporate debtor. And then at the end, you will have the waterfall mechanism. Now, when I say this waterfall mechanism is very important, because the code has very explicitly written down that in the event of liquidation of the company, how are the assets to be distributed. So it's kind of a waterfall which says primarily the first payout will be to the insolvency resolution process and the liquidation cost. So that cost gets paid out first on liquidation. You will then have the secured creditor, but only in case he has relinquished the security. If the security is not relinquished, then they'll not come into picture. And then you will have the workman's dues along with the secured creditors for a period of 24 months preceding the liquidation commencement date. Then you have the wages and unpaid dues, and then you will have the unsecured creditors, then central government and state government dues, plus secured creditors for an unrealized amounts enforcing the security interest, and then you will have the remaining debts or dues. So if you look at this particular chart here, you will come to know that financial creditors have always been put up in an upper place as compared to the operational creditors, as compared even to the government dues. So we have to understand this waterfall mechanism very well, and this is called as the priority, which has been clearly stated out under the code. That is also one of the objects, that the priority has been clearly mentioned as to how the payouts have to be done, so that tomorrow there is no question about who gets paid first or who doesn't get paid. Coming to our next slide, this is all about so far as to how the entire insolvency process takes place, followed by the liquidation process in the event the company goes for liquidation. Otherwise, the company has been revived. I shall now take you quickly through the recent amendments which have come in place because of COVID-19. Now, these amendments are very important, and the reason why I'm going to mention these amendments is because this has been a very big shift in our entire law. not just I would say to the code, but it has gotten a lot of questions, lot of issues, untested waters. So it is better that we try to analyze each of these particular amendments which have come into place because of this COVID-19. So what we have is actually COVID-19 important amendments. I'm not going to deal with all the amendments, but the three primary amendments which have come into picture are: first, the minimum default has been increased to rupees 1 crore from rupees 1 lakh. Second, we have suspension of section 7, 9 and 10. And third is relaxation and timelines under the IPC. I shall deal with each one in detail. So the first amendment, that is increase in the minimum default. Now, initially, if we had to knock the doors of NCLT, we needed a debt which was due for more than rupees 1 lakh. So if somebody had to pay rupees 1 lakh and was unable to pay, so if a company was unable to pay rupees 1 lakh, we could have taken the company to NCLT under the insolvency law. But this trigger point of 1 lakh has now been increased to 1 crore, and this has been done on the by the government by notification in March. So it is done on the 24th of March 2020, as a result of which 1 lakh trigger point has now become rupees 1 crore. Now, what is important here to understand is whether this particular amendment is prospective in nature or it is retrospective in nature. Now, we are very clear on this particular thing that something that affects a substantive law cannot be retrospective in nature, and it has to always be prospective. So, it could be prospective, it could be retrospective, because this is an untested water. Now, why am I saying that it could be prospective and it could be retrospective? I shall explain in detail. Now, here comes the reason of prospective and retrospective. We have three kinds of categories when this particular amendment came into picture. First was the admission, the cases which are pending before NCLT, which are the admitted petitions. Second case, filed petitions but are pending the admission. And third cases, that demand notices have been issued, okay, but the petition has not been filed. So there are three types of cases. So in case where there is an admitted petition, of course, this provision will not apply because the petition is already admitted and the CIRP process has commenced, and it will follow the actual process which is there in place. Second, filed petitions pending admissions. Now, this is where the actual problem will come in, because we have petitions which we have filed which will be less than 1 crore of rupees, but they are yet to be admitted. So how the court will deal with such kind of a provision? Now, if we see, there was a home buyer's case, whether a home buyer would be considered as a financial creditor and whether a home buyer could file a case in NCLT. So what had happened that this particular case is still pending judgment in the Supreme Court. But what had happened was, in this particular case, a criteria was fixed, as a result of which all the home buyers who had filed their petitions were asked to match this particular criteria in view of the amendment which had come in. Now, the court gave permissions to the home buyers to satisfy that criteria. So, it could happen that the court may give the creditors a chance that either, if your particular debt does not match 1 crore, either you try to match it to 1 crore by aggregating all the creditors together. But when I say aggregating all the creditors together, this is only available for financial creditors. This option is not available for the operational creditors, and therefore they will not be able to aggregate the debt to 1 crore of rupees. So this will be kind of an untested waters. We'll have to wait and see how the NCLT actually approaches such situation. And as far as the third case is concerned, the demand notices have been issued for amounts which will be less than 1 crore, but the cases are not yet filed. So in such situation, it may happen that the court would consider filing of the petition um, to just match the trigger point of 1 crore and may not permit them to file for a amount which is less than 1 crore. It may not. Maybe we can await a clarification on this particular point, but however, this still needs to be tested with time. And another important thing with regards to this notification coming into place is that this notification was not just because of COVID-19. The government was trying to implement this particular thing because many creditors were trying to use insolvency code as a recovery code and not as a revival of the company. So it was more like extortion of money because they were like, okay, we'll liquidate your company if you do not pay us our debt. But that cannot be the case. It has to be that it purely the company is unable to make the payment and hence you go for the insolvency. So to avoid these kind of situations, the court was what the government was trying to do is to increase this limit to 1 crore and not keep it just 1 lakh, because many operational creditors have dues like 16 lakhs, 20 lakhs. So they were actually using it as a recovery tool and taking every company to the court, and as a result of which settling their dues. So it would be that the intent of this particular enactment or this particular notification was not just COVID-19, but the way this code was being treated as a recovery tool. Now, what are the impacts of this particular notification? The notification has resulted in a very positive impact for the MSMEs because these are small scale industries. And so, in these cases, the deaths might be small in nature, so they get a revival time. They get a revival time, as a result of which this revival would lead to, they getting time and being able to pay their debts and not go forward. But the negative impact that has resulted is that the shift of burden from corporate debtor to personal guarantors. Now, like I said, the personal guarantors provisions have been notified in the year 2019, December 2019. But the trigger point there is only rupees 1,000. So if the corporate debtor owes rupees 16 lakhs, if you cannot proceed against the corporate debtor because of this 1 crore trigger point, you can definitely proceed against the personal guarantors because there the threshold limit is just rupees 1,000. So this has resulted on a negative impact for the personal guarantors. So we should actually wait to see whether this personal guarantors threshold limit also changes with time. And then the third impact is to the operational creditors, because largely the operational creditors and even the financial creditors would also be impacted, because if they do not have a debt which is more than 1 crore of rupees, they will not be able to trigger the insolvency code. So these are basically the positive and negative impact of the first amendment which came in on 24th of March. Here I've also laid down a few examples which will help us to understand this trigger point of 1 crore of rupees. So if I would just not get into the details here, but I will just explain to you that in case of financial creditors, the aggregation of all the financial creditors is possible, and financial creditors can come in together and file for their debt, and thus making their debt to 1 crore. If one financial creditor has a debt beyond 1 crore, he can easily invoke the insolvency code. But if there are two financial creditors having a debt which is less than 1 crore of rupees, then the two of them can come together and file for the insolvency, for the only reason that aggregation of financial creditors is possible. However, this is not the case of operational creditors. Operational creditors cannot operate together. They have to individually file for their claims, and as a result of which, the operational creditors under Section 9 can only file if their debt is above 1 crore. So if there are three operational creditors and they are having various debts of 30 lakhs and one of 75 lakhs, one of 2 crore of rupees, all three can't come in together. A person with 30 lakhs will not be able to invoke the insolvency code in light of this notification. But of course, the one with 2 crore of rupees can invoke because he matches the threshold limit. Moving on to my next amendment is the suspension of section 7, 9 and 10. Now section 7 is the financial creditors invoking the insolvency code. Section 9 is the operational creditors invoking the code, and Section 10 is the voluntary invocation by the corporate debtor. So what has happened is that this particular ordinance of 5th June 2020 has come into being, and it has stated that a particular period, okay, it's a specified period which starts from 25th of March 2020 and continues for a period of 6 months, or such period not exceeding 1 year, shall be excluded, or you will not be able to file any proceedings for any default that may have happened between this specified period. Now, this is very important to be noted. Never in law till date we have seen such a situation where the entire law has, or rather, you've seen a situation where the law has been prohibiting someone to file a petition in the court for this particular period. Till date, we always had a notification or a section saying that you cannot file, but this is a blanket prohibition of the fact that any default, be it during this period, cannot file an insolvency. So in the event after the expiry of this specified period there is a default, then there shall be no inquiries, or there shall be no institution with regards to any default that has occurred during this specified period. Now, what are the pros and cons of this particular thing? That in this current COVID times, it has definitely given a breather to many companies to revive, because yes, we know that the economic current situation is really bad, and therefore people will try to revive themselves and they will not be pulled to the court. But at the same time, if there is a default which is not due to the actual reasons of COVID 19, but definitely the business was not viable, or the default was such that the promoters and the directors were responsible for the same, then such period will go unnoticed, and as a result of which would lead to unnecessary further litigation. So it is better, it is important that some kind of a clarification also comes with regards to this prohibition which has come in, which is like a blanket prohibition for initiation of any kind of proceedings, but for a default during this period. Of course, many companies have definitely benefited from this particular sections because they stand to get more time to revive the economy, as the economy has definitely taken a hit in this current situation. Moving to the next part is the relaxations in timelines. Now, what is the relaxation in the timelines that have come in? One, we have the IBBI notification and the NCLT order. IBBI is the Insolvency Bankruptcy Board of India. They have relaxed these particular timelines. That is, the court timelines are very important as to when the public announcements have to be made, when the information memorandum has to come in place. So those procedural aspects, there are fixed timelines. So they have given an ease to them because of the light of COVID-19. They have regulated it. However, they have stated that this lockdown period can be excluded, but definitely cannot exceed the 330-day period which has been given under the code. NCLAT has also suo moto taken up the matters and have given the timelines that all interim orders have been stayed, and they have increased the timelines given for filing of appeals. But however, the NCLAT order shall deal only as far as the tribunal orders are concerned, or as far as the applications to be made to higher courts, lower courts, as far as those proceedings are concerned. NCLAT order shall not deal with the procedural timelines, but that has been cleared by the IBBI notification. With these timeline relaxations, I would like to end the slideshow here. And with this, I would just state it one thing, that these amendments have definitely helped the economy. At the same time, it's going to bring a lot of questions forward to us. And I will also end my entire session today with the fact that I've given an entire overview of the Insolvency and Bankruptcy Code and the analysis of the current amendments. I would like Xenia to come into picture if she is available.
There are a few questions that have lined up. And for the participants, notice some of the questions were answered by ma'am during your discourse. So I'd like to relay the other questions, ma'am. The first one being whether lender to home buyer can initiate CIRP.
Could you repeat the question again?
Whether lender to home buyer can or home buyer can initiate CIRP.
A lender to a home buyer.
Whether lender or home buyer can initiate
Or
CIRP.
home buyer. Okay.
Yes,
Yeah,
yes.
a lender or a home buyer can initiate the CIRP, but as far as a home buyer is concerned, he is required to satisfy those criteria. That is a 10% criteria which has been laid down in the Act, and therefore those particular criteria have to be satisfied. If you're considering a lender, yes, he is a financial creditor in that sense. If he is a lender with interest and time value of the money, and therefore, yes, a lender can initiate a CIRP process.
The next question is, where do you see the unpaid sellers having lien on corporate debtor in the scheme of IBC, especially liquidation? Are they secured or unsecured creditors?
So if they have a lien on the assets of the company, then in that case they would fall under the secured category. But then again, you have to understand that it would be they'll have to identify whether they'll qualify as a financial creditor or as an operational creditor. So we need to first figure out that the type of the agreement that has been executed, whether it was with the purpose to lend money for the purpose of the goods that have been provided, or it is a good service. If it's a purely a good service and that just the lien has been created, then it will surely fall under the operational creditors category.
The next question being, can IBC be invoked against individuals?
So that I've already explained that IBC will not be, because the provisions are yet to be notified. As far as personal guarantors to corporate debtors, yes, you can invoke because they've just recently been notified. But as far as individuals are concerned, the law is not yet notified.
We have two more questions, ma'am. Has the IBC currently made the process of doing business less cumbersome?
Yes, it has definitely done so, because it has increased the credit facility, it has increased entrepreneurship, as a result of which people are coming forward and taking up the businesses which are not doing good. As a result of this, it's becoming easier for people to come forward and understand the insolvency. We are reducing on the NPAs here. So, the banks also come into a very stable situation. So the lending power of the banks also increase. So considering all the factors that it's actually trying to cater, it is a very good thing for our current economy, because if you see the statistical data also till date, there are a lot of monies which have been recovered under this entire process. So it's not like a recovery process, but the loans are getting restructured. Then the banks are giving more credit facilities, knowing that the company can continue to do business further. So this has definitely, yes, I would say it has increased.
Ma'am, the last question is, what do you think about asset reconstruction company not being allowed to bid under IBC?
Sorry, could you repeat the question again?
What do you think about asset reconstruction company not being allowed to bid under IBC?
So, it see, like I said, even the promoters have come into the category of strict restrictions about whether they can bid for the company. And here it's the question of not bidding the company. Like I mentioned, asset restructuring companies are basically, they take over the company and sell off the companies by and large. So asset reconstruction companies do not continue the business as a going concern. Many occasions they will try to recover the assets. Okay, but as far as if we call for these resolution applicants, they are the ones who are supposed to take forward the business of the company. They're supposed to continue the company as a going concern. So you cannot say that you cannot actually have the asset reconstruction companies to come just take over the assets, because the entire object of the code, like I mentioned, is the maximization of the assets of the company and the revival of the company. It is not the sale of the company, which is strictly prohibited under the code. So definitely will not prefer any sale happening of the company. Otherwise, we will not call it as a revival. Then the code will become like a recovery code. So definitely that is not the object of the code, and hence we have this.
Ma'am, with this, we come to an end of the question and answer session. I'd like to extend my profuse thanks to you for the highly insightful, informative, and a very lucid session. I received the same comments from the participants as well, that it was highly informative and a very insightful session.
Thank you so much.
I'd like to thank our management, our beloved principal, sir, Dr. J.M. Mallikarjunaya, and the conference committee members here for having facilitated this event. I'd like to extend my hearty thanks and congratulations to all of the active participants in here. And I'd request them to kindly fill in the feedback form that has been shared, and tune into tomorrow's session as well of our webinar series on commercial laws. Thank you all. Thank you all.
Thank you.
Thank you so much, ma'am.